Good morning and welcome to MSO's 13th Annual Educational Seminar. Thank you for attending. At this time, we would like to thank our generous sponsors who make our events possible. And they are listed on the screen. We especially wish to thank our annual sponsors who help make our ed seminars, webinars, and golf outings possible. And also our incredible MSO team who works so hard to get these seminars put together. Finding presenters, getting sponsors, creating all marketing and program materials. Before we start, a few housekeeping rules. Attendees are on mute. Questions should be posted in the chat of the Q&A, and we will answer them as time permits. We'll be adding a link to the program in the chat. Thank you, Mary. The speaker bios can be found in the program along with information on all of our sponsors. You should also have received the program yesterday by email. The sessions are being recorded and will be available on our website and YouTube channel shortly after the seminars. Copies of the PowerPoint slides will also be available. Today's sessions have been approved for 2 continuing education credits in Connecticut, Delaware, Pennsylvania, Vermont, New England, Nebraska, West Virginia, New Hampshire, and New Jersey. If you need CE, please be sure to answer the polling questions that will appear during each session. There will be at least 2. Failure to complete the polling questions means you will get no credit. If also failure to supply your license number, state, and NIPR number may prevent you from receiving credits. Here are antitrust compliance and discussion guidelines. We will not be sharing any company information with each other. And these presentations are for educational discussion purposes only. We are not insurance or legal advice, even though some of our presenters are lawyers. As I said before, attendees must answer all poll questions to receive CE credits. Our first presenter is William Roberts of Dave Pitney, speaking on handling data breaches. Bill is very excited to be joining the YouTube crowd. He feels like he'll soon be an influencer on the level of Kim Kardashian. He paid me to say that. Bill, take it away.
I think Kim Kardashian might be a little out of my reach, but I am excited to be on YouTube for the first time. So Sue, thank you for that very kind introduction. And again, for the audience, my name is Bill Roberts. I'm a partner at the law firm Dave Pitney. We're an East Coast firm with about 350 lawyers, and I'm based out of the firm's Hartford, Connecticut office. So what we're going to jump into now is, let me share my screen. As mentioned, we're going to jump right into the presentation regarding handling data breaches. And try this in the slideshow mode. Okay, perfect. What we're going to be covering today, 3 things: the data breach landscape, a survey of legal obligations, and then most importantly for everyone on this call is developing and implementing a data breach response plan. We're not going to be talking about preventing breaches here. First, this isn't a cybersecurity presentation per se, it's a legal one. And what I want to do as well is really focus on the reality that, well, there's many things that everyone on this call can do to reduce the likelihood of a breach or reduce the severity of a breach. The reality is that breaches will happen. Bad breaches happen to good companies. And the most important thing then is to not so much, because you can't be breach proof, to be breach ready. And that's really the take home here. Quick note on the slides, I certainly encourage you to obtain a copy of these, as Sue mentioned in the intro. There's a lot of slides, particularly at the end, which I've drafted specifically as take-home slides. Take-home ones, some checklists, some sample language for you to bring back to your business and either use to help develop a plan or to review your current plan. So this is a quote from a recent executive briefing from Deloitte. And I just want to highlight a few things here. First is the first line: cyber attacks in the insurance sector are growing exponentially. This is particularly true given the greater reliance upon online tools, whether it's telematics or wearables or sensors, or whether it's personal or health or mechanical. All of these things just increase the volume of risk and the surface for risk of a data breach. You don't have to try very hard to learn to find data breaches in this sector. This is just some headlines from major reported breaches just in the last 10 months or so. They're extremely common, and they happen daily. So again, this is all about being breach ready, so that when a breach happens, you know how to respond to it and how to respond in a timely manner. And that's really the key point for this presentation, is that where I see companies get in trouble for breaches isn't so much that the breach occurred, because everyone has a breach. Companies get in trouble for how they respond to the breach. That response is 98%. It's all about preparing ahead of time. And then once the breach happens, how you respond. Is your response appropriate, and is it catered towards the specifics of the breach? Such a couple other stats in case folks just by the off chance are not aware of all of this. But I think what really is shocking to me is the second bullet point from a website called securityscorecard.com. Typical insurance organization has an average of 113 targeted breach attempts. That's not phishing. That's not like the firewall, the random attacks your firewall gets 50,000 times a year. These are targeted attacks against your organization or against an employee of your organization. So things like social and engineering attacks, for example. And the reason for this emphasis on insurance is really broken down here into three things. All of us handle a tremendously large amount of data. That data is sensitive. It's about healthcare. It's about your business risks. It's about your facilities. It's about your employees and so forth. Insurance relies upon a lot of vendors, who many of you on this call are the vendors. You're the producers, you're the agents, you're the tech companies, the insure tech companies. And the other thing is, most Americans have insurance of some type, whether it's public or private, or property, auto, casualty, life, etc. So the top threats, like this is, again, you kind of going with, isn't going to be the focus here, but I said we're going to be talking about how to handle breaches, not prevent breaches. But the sort of, when you're thinking about working with your cybersecurity vendors and your cybersecurity advisors, these are really the threats that you want to plan against. Again, you can't be 100% breach proof, but it's important to recognize the top cyber threats that your organization faces and develop tools and training and policies to address these. The first is ransomware, the nightmare of probably everyone in the IT department. You show up on Monday morning, your systems are locked down, and you owe $3 million in Bitcoin to some random criminal group. Phishing, you're all familiar with these. This is like, oh, you want a $50 gift card to Dunkin' Donuts. Just press this link. Don't press it. Business email compromise. These are your wire frauds. This is when many of you may have seen this. Unfortunately, with our clients, we see this about every 2 weeks or so, where someone a cyber criminal impersonates a vendor or an accounts payable person, and they trick a company into wiring money to the criminal's account. Social and engineering, also called masquerading, is similar. This is where someone pretends to be your CFO, for example, and are able to carry out cyber crimes that way. The most dangerous, from our perspective at least, is insider threats. There's no breach more difficult to respond to when the cyber criminal is your director of IT, for example, or your director of HR. Those are the most dangerous. You don't see them too often, but we see 5 or 6 a year. And then also to note the rise of AI powered threats. This is beginning. Obviously, everyone's talking about AI all the time for good reason, but AI is now being used to power the types of cyber threats we talk about up here. It's being used to target phishing. It's being used to make more sophisticated phishing, more sophisticated social and engineering. So even though our protections are growing, even though awareness is growing and training is growing, sort of like the evolution, that the more secure companies get, the more aggressive and the faster that the cyber criminals will be getting as well. So we're going to spend a few minutes, because I'm a lawyer and this is the legal presentation, so we can't get through a presentation without talking about the law at least a little bit. What's most important here when you're looking at your own data breach response policies is to understand what laws you are subject to. And that's often a very difficult process, because what you want to do is design your data breach response process, of course, in accordance with the laws that apply to your business. This is for a few reasons. First, the obvious one, you want to comply with the law. This is the only way to ensure a favorable outcome when dealing with an attorney general or a department of insurance matter. It also protects you against litigation from your members or a class action, because what they'll do is say, a company's failure to comply with the law is itself negligent or is itself reckless, and that can lead to very serious damages. So you want to think about, where are we doing business, what state, what sector, and importantly, are we doing business out of the United States? Of those, European Union and Canada are probably the two most significant, but also other countries such as Brazil and India also have comprehensive data privacy laws. So in the United States, this is primarily referenced. We're not going to go through all of this. There's two federal laws and a set of state laws that I just want to highlight. First, everyone needs to be aware of Gramm-Leach-Bliley. It's been around for a long time, but we still see insurance sector businesses, particularly service providers or producers and the like, not in full compliance. So it's really important to look at, is your business compliant with Gramm-Leach-Bliley? And very recently, which required a somewhat last-minute edit to these slides, on October 27th, the FTC announced new breach reporting rules for non-bank financial institutions. The second sub-bullet goes through a lot of that, whether mortgage and credit reporting, accountants, tax prep. So it is important to consider if your business is going to be caught up in these new expanded reporting requirements. Very important. This is probably the most significant data breach related change to Gramm-Leach-Bliley in years. HIPAA. So I don't know how many of you on here are involved with health insurance companies, but HIPAA, as we all know, is the primary federal law for healthcare privacy. It's the law that applies when you go to the doctors or the dentist, and it also applies to health plans, health insurance companies, and their vendors that receive plan member data. So some of you may be familiar with the term being a business associate and signing a business associate agreement. These are very, very important to have. It probably the most important check the box item when you're a business associate to protect yourself from liability by U.S. Department of Health and Human Services to make sure you have a business associate agreement in place when you're providing service on behalf of a health plan or health insurance company. Because it's really important to keep in mind this last point. Vendors can be held directly liable under HIPAA for not reporting a breach on time and not having a business associate agreement. The last bucket, just to highlight, is U.S. state laws. Every single state and certain territories have a data breach reporting requirement. Many states have multiple ones. They have personal data breach laws. They have cybersecurity incident reporting laws. Some of these are generally applicable to all companies. Some are special through like an insurance department bulletin. Some are government contractor specific. So if you're doing something on behalf of the government regarding a public benefit plan, for example. The most recent is a change in New Jersey that includes data breach reporting requirements for government contractors specifically. They go way beyond New Jersey's existing laws. So it is important, again, to keep in mind, where are you doing business, who are you doing business with, and make sure you're aware of and are complying with these state laws as they relate to investigating and responding to a data breach. Okay, I think everyone now look at poll number 1 regarding data breach. Give everyone a minute. As Sue mentioned, you do need to respond in order to get credit. So if folks are submitting their responses to poll number 1, I also wanted to mention one other point. While your focus should be on looking at, of course, what federal and state laws you need to comply with, even if you're not subject to any of these somehow, or just a handful, the law isn't your only source of data breach reporting requirements. You have to look at your agreements with customers, because many of these, and increasingly, we always have our clients use this, for example, is including data breach reporting as a contractual requirement. Sometimes we stick it in security terms. My personal preference is a data processing agreement, but sometimes they even live in online terms, for example, which you may not be as carefully reviewing as you should be. So it's really important here to protect you, again, from a breach of contract claim or negligence for failing to comply with your requirements. So we have the results here of poll number 1. The first is, do you work for a company that has a written incident response plan? 71% of you say yes. That's a decent number, though I do admit that it's lower than I had expected. So for those of you in the no column, again, please be sure to look at some of the later slides. You're taking them home. And then we're going to talk about responding to this breach in details. And one of the questions here, which is interesting, is have you participated in an exercise to practice the plan, such as a mock breach or a tabletop? And only 6 people said yes. We're going to get to this in a few minutes, but an incident response plan is, the end of the day, it's really just a piece of paper or a packet of papers. It's not worth a whole lot unless your business knows what it says and knows how to use it. And the only way you get good at responding to breaches is to practice, just like a sport, for example. So I do encourage to take an hour a year to start, to really focus on knowing what your plan says and knowing how to use it. Because when you have a breach, that's not the time to dust off the piece of paper. So moving into our next section, being breach ready. Like I've mentioned a few times, you can't be breach proof. You need to be breach ready. The first step of that is to understand the cyber threats that that exist and are a threat to your organization, which we've gone through some of those. Work with your IT department, your cybersecurity experts to fortify and protect your business. You want to adopt policies and procedures for workforce members to educate them on what they're supposed to be doing, how to use the cybersecurity protections that your business has, and training them. And then what we're going to cover here is two things that every business should have. And I know 70% of you have an incident response plan. Make sure you're using it and make sure you're reviewing it. And then the other aspect is a vendor data breach strategy. And we're going to talk about a vendor data breach strategy because so often that when your organization has a breach, it's not actually occurring at your business or on your systems. It's you're having a breach because your vendor or their vendor's vendor had a breach. So it's really important to be able to have a strategy for how to be ready for that downstream breach occurring. So for the rest of this presentation, we're going to spend some time going through what should be in your response plan and how your business should be thinking about a vendor data breach strategy. But before we do, I want to pause here and see if there's any questions, either through the chat or otherwise. And it looks like there are. But they're all about the poll questions. Anyone have any questions about anything we've covered thus far in terms of cyber threats, in terms of fortification, in terms of the risks? Seeing none, we're going to dive right now into an incident response plan.
We do have one.
Oh, okay.
Since you talked about practicing the response plan, can you give an example, which I think is what you're about to do?
Yeah, certainly. So we'll just cover this now. So this is the time of year in which we're doing it. Most of my clients have a data breach tabletop or mock exercise as one of their organizational goals. And it's normally done in Q4. I have about one a week now. These range from anywhere from 60 minutes to 8 hours in length, depending upon the organization. So what you do in this mock breach or tabletop is that you'll engage a third party, whether it's your counsel or cybersecurity company, to come in and create a fake breach in which you bring together your incident response team. And let's actually go to this next slide. You're going to bring together your incident response leadership in a room or on a Zoom and have the facilitator present a mock breach to you. And what for example, I'll say is that we're starting at 10 o'clock. Everyone's on the Zoom or all around the conference room table. And here's the email you get from your vendor, or here's the voice message you get from one of your employees. And then to actually walk through the entire breach plan so you know who to call, you know who needs to be at the table, and the facilitator will guide you, saying, who's your legal counsel for this? Do you have their number? Are they familiar with your business? Who's your forensic IT vendor? Do you have cybersecurity insurance? Who's supposed to call them? And to really go through in detail all of the steps so that when a breach happens, you're familiar with how the process flows. It's really about exercising your response to the breach and using the plan. So that's kind of what we're talking about here. Again, anywhere from 60 minutes to a full day. For most small to mid-size organizations, I would say 2 hours would be ideal. And again, that's only 2 hours a year. It's really, really valuable. So let's talk about the goals of having an incident response plan. First is you want to define this incident response process. Provide guidelines for establishing a timely, consistent, and repeatable process. You want to be able to move quickly and efficiently. You do not want to be trying to figure out who to call, who to use, who does what, because that's just going to be wasting time. And you really want to be thinking about this as a show, because when a breach happens, you're on. Everything you do from that moment on will be looked at by the government, will be looked at by law and enforcement, and will be looked at by plaintiffs' counsel, those trying to sue you. So everything you do ideally should be orchestrated so that when plaintiffs' counsel files a claim, or the attorney general or the DOI submits a list of requests regarding the breach, the best outcome there is to have an incident response plan and a process that you followed, and you followed well in an organized and calm manner, so that you could just simply show the attorney general, yes, we're a good company, a bad breach occurred, but look at everything we did. Look at our emails, look at our timeline, look how organized we were. And 90% of the time, at least, they're going to say, you know what, great job, thank you. And we just had that a couple of weeks ago with a banking client, suffered a terrible breach. They're extremely well prepared. We put the whole response like as a show. The banking department and the attorney general and the Federal Reserve came in, and instead of getting a notice or any sort of penalty, the head of the bank actually got a thank you email from the Federal Reserve being like, this is exactly how we want you to be handling things. So that's really what this is about, knowing what to do, being able to exercise that, and putting on a show. You want to be looking good. This is your time to shine. And this is why you want to be practicing it. The first and most important part of an incident response plan is the leadership. There needs to be someone or a group of people, depending upon the size of your organization, to take charge of the plan, to own the plan, to be responsible for revising the plan, practicing the plan, and implementing the plan. You need to have someone or a group in charge for when the breach happens. A big mistake a lot of companies make is by equating incident response leadership with an IT function. While IT plays a role, a breach response is not fundamentally an IT or IS responsibility. A breach response fundamentally is a business and legal responsibility. IT, of course, plays a role, in terms of figuring out what happened, fixing your systems, getting rid of the malware. But the breach response itself is about ensuring you're complying with the law, ensuring you're doing the right things by your employees, ensuring you're keeping your members, your plan members happy, your corporate customers happy. And that's not IT's job. That's a business and administrative job. So I normally see breaches responded to best when someone like in legal or administration, a senior leader in the business, is in charge and directing IT what to do and leaving IT to do what they do best, which is the technical side, not the big picture side. And it's also a really quick point in this last one, backups. Because it's a saying, but it's extremely true. Breaches only happen when you go on vacation or when someone is on parental leave. that's when breaches occur. So you always want to have backups who are involved with the process, who have the authority to control the breach and the knowledge. You want the backups always included with your trainings. So let's go through a checklist. And this is, one of those slides that I mentioned why I kind of drafted to bring home. For those, the 70% of you whose businesses have a plan, bring this home, use it as a double check. For those who don't have a plan, work with your legal counsel on devising a plan and making sure it addresses these points. The first one we are already talked about, and it is, has it been drafted to comply with the law? You need to know what laws you are subject to and which ones you need to comply with, because they require different timelines, they define breaches differently, and they have different notification responsibilities. You want to have a clearly defined scope. You want to know what are breaches, like what do you need to be worried about? One mistake some make is only doing this as a cyber response plan. You have to keep in mind there's still paper records, and this is particularly true for HR data. So you want to be making sure that it covers all potential types of harms and all potential types of attacks. Identify a role or committee to be in charge. This is the IRP leadership that we just talked about on the prior slide. Sometimes you could have one person, but a larger organization may want to have one person supported by a committee. So the committee is often someone from, let's say if like the leadership, for example, is the CFO or COO, for example. The committee may be internal or external counsel. It may be internal, external IT. It could be the head of customer relations. And it's also good to have someone from human resources as well to manage communications and questions from your workforce, and particularly if the breach involves your employees' personal data. So you want to be very clear on who that team is, who's your resources. If you violate this policy, it needs to be a sanction. So you need to be able to utilize your HR policies, your employee handbook to sanction people for violating this policy. You want to make sure they're empowered. Big mistake with having IT in charge is that the head of IT often doesn't have the authority even to make the decisions that are necessary to communicate with employees, communicate with customers, communicate with your board, your investors. You want to make sure that the person in charge has the authority to make the big decisions. And then everyone else have clear responsibilities and clear roles. You want to address the role of external parties. The three big ones is like forensic IT, cybersecurity support. Don't mistake your internal IT with cybersecurity. Cybersecurity professionals and IT professionals are not the same thing. If you have someone in your IT department who manages your help desk, your firewall, and installs printers, they're very likely not the right person to respond to the breach. So when you have a cybersecurity attack, you want cybersecurity professionals responding to it, not IT folks. And I could go on for hours about stories of that going very poorly. It's different skill set. You want to have procedures for detection and discovery. If someone finds out about something, who do you call? Who do you send an email to? What if your email's down? What if it's the weekend? What if your phone service is down? How do you communicate? That's really vital, because there's going to be a lens, there's going to be a microscope on everything you do from the moment the breach is discovered till you respond to it. And you don't want to show that your employees had no idea who to call or what to do. You want to figure out, what steps should you be taking to investigate the breach? What questions should you be asking? You want to make sure you keep some documentation. And you also want to be, working with an attorney to figure out what documentation. So because this cuts both ways. If the breach response is going well, yeah, you do want to document that because it's extremely valuable to defend your company. You also want to have a record of what you did and when, because it could be a year later that the insurance department opens up a file against your company, and they want to know what time was this email sent, for example. But even the best managed breaches even the best prepared companies don't always have the best managed breaches. A lot of different fact patterns, things can get a bit messy. So you don't want to over document and give plaintiffs' attorneys basically just write their case for them. So you want to be really clear on what documentation is required and the limits to what you're including, because the documentation can be your best defense, but could also completely sink you in a class action lawsuit. You want to have a team. So this could be the same or could be different than the people on the committee. Maybe a particular breach requires a specific set of persons. Maybe this is a breach involving a particular customer's data. So you're going to want to have sales, you want to have the account reps and them on the team. Rather than like a breach affecting your HR data, like let's say your W-2s were stolen, you're going to have that team. You're going to want to have the response leadership designated team more heavily geared towards employee relations. You're going to want to know, kind of going back to the very first thing, like what laws apply. And then also my slide about what do your contracts say. When a breach happens is not the time to figure out what the law requires. It's not a time to figure out what your contracts require. Some of these contracts may have like 48 hours. You're not going to have time to be going through them. You want to know ahead of time so that when you look at the plan, okay, we need to notify this particular state's Department of Insurance within 72 hours. And we have this one big customer that's super important to us, and they require notice in 3 days, even though the law says 30 days. You want to know that ahead of time, have that in the plan. What I often like to do is have like an addendum to the plan saying like, this is all of our requirements. This is everything we've agreed to, so it's current. And then have a process for post-incident review. When everything's done, when you've handled this successfully, when you get a thank you note from the insurance department and a gold star, you want to be able to pause and look at what went well and what went wrong, because every breach should be a learning opportunity. Okay, so the last slide of our checklist here, and before I get there, I think there's a question, so let me pull it up. What if the leaders do? Now, this is a great question. One I get a lot. What if the leaders in your business do not want to spend the time or money to do all of this? We see that a lot. I think there is a mentality among some businesses that a breach won't happen to us. We have great cybersecurity. Sometimes this comes from the mouth of a overly confident director of IT, because there are sometimes the interests are not necessarily aligned, where the board or the suite will ask, they'll tell, hey, IT department, we just gave you a budget of $1 million. So someone just asked, does everyone see a gray box on the screen? I wonder if that's my question panel. So I'm going to close the questions and see if that helps. Hopefully that helps. It looks like every time I read questions, it makes a box. So you want to educate people. You want to educate senior leadership that you appreciate all the money that they're spending on IT, but that IT is not foolproof. Now, no matter what your budget is, it's not going to be 100%. And also educate them on the harms. So what we're talking about here in terms of spending time and money is a drop in the bucket compared to the costs of a breach, and particularly the cost of a breach response gone poorly, between penalties and lawsuits and other harms with customer relations, harms with goodwill and your reputation. So I think it's an educational process to demonstrate that, like as the saying goes, an ounce of prevention. That's really what we're talking about here. So going through the rest of this plan, testing the plan, which was that fantastic question about mock breaches, also called tabletops or sandboxes. People have a lot of different cute names for it. You want to be trained on it. If your policy says everyone to send an email to privacy@producer.com, doesn't do any good unless people know that. You want to be looking at the plan. Like once a year, you should set aside time with your counsel to look at the plan, because the laws are changing constantly. There's really no month goes by where the government isn't changing some requirement regarding breaches. It's a very rapidly moving space right now. If you're public, I don't know if anyone on here is, SEC requirements, very, very strict now in terms of your 8Ks and material harms. If you have a board or an audit committee, you want to address the role that they play. Often it could be like a once a year reporting or an update, or they get notice of certain breaches. You want to look at how you're going to treat your vendors, which is the next topic here. And then you also want to think about insurance. I know we're all in insurance here, but you want to think about what insurances you have, whether it's cyber or E&O or something similar that may apply to some of these breaches. So we're going to move on to, if I can, third-party vendor breaches. So before I mentioned that one of the biggest risks that an insurance sector client faces is a breach happening at one of their vendors. And some of you may be familiar with the MOVEit breach from this past summer that's still going on. MOVEit was a file transfer, a quote unquote secure file transfer service. And we've had several clients affected by it, all of which though were affected by it because their vendors or their vendors' vendors used MOVEit. So you really want us to think about what kind of requirements are we going to impose upon our vendors, and which ones do we want them to flow down, so that when a breach happens at a vendor 4 times removed, we want to be able to know about that quickly. We want to be able to know what rights we have, what control we have, and what data we're going to be getting. Because that's a very frustrating spot to be in when you're required to provide notice, but the breach happened 4 months ago and you're just hearing about it now. It's a really difficult thing to explain to your customers and to your members. IT vendors and software vendors are probably the highest risk. Things like cloud storage, secure file transfers like MOVEit and the like. Other ones to keep in mind are your law firms. Lawyers, we tend to know all the to dirt. That's why there's such thing as privilege. Law firms, many of the country's largest firms, this past summer were hit by breaches. HR, payroll, and benefit vendors. I know some of these could be you, so but they're often hit as well. But this is really across vendors, and it's really nice to have a vendor contracting strategy. So when you engage with vendors, that you have a standard set of language. And I normally like to do it, but what I do for our clients is like a standalone data privacy and security addendum, which you just slap on the back of your agreement. That's really key. You can't always negotiate these, of course, with Amazon, for example, but often what happens, even with the largest companies, they'll see your addendum, they'll remove it and offer you theirs. And that often gets you 80% of the way there, which is really, really valuable. So what you want to do is three things: set forth in detail what you expect from your vendors in the event of a breach. You want to be very, very clear and very precise. Breaches are not the time for vague language. It's not the time for general words like promptly tell us. Like, what does that mean? You're going to be dealing with lawyers who will debate what the word "the" means. So you want to be extremely, extremely clear. And then you also want to balance speed and being thorough. And we're going to talk about that as well in these next few slides. So this is kind of like the overview section here. And there's really a couple goals of this, whether you include it as a section, whether you include it as an addendum. You want to carefully define what is an incident so that people know what to report. You want to balance knowing too much and not enough. And then you also want to be really clear on when they're supposed to report it, when it's discovered or when it's known. This is the start of everything, telling your vendor what they need to report and defining that for them. So some of you may have seen some of this language in your agreements. This is just examples, not recommendations or advice. These are very, very simple terms. Notice of an incident shall be provided within 10 business days, for example. But when you're looking at it, use this checklist here. This is really the issue spotting checklist when you're developing your vendor breach response strategy with respect to the duty to report. What is an incident? What does it include? What does it exclude? At what point does the obligation come into play? Is it when your vendor actually knows of a breach? When they suspect a breach? What does know mean? When they reasonably should have known, for example? When they know something happened, but they don't know that personal data was affected? That kind of thing. What about a breach, the scope of the breach? What about, is it a breach affecting only your relationship with them? Or do you want to know about a breach happening more broadly at their entity? There needs to be a degree of certainty as well. Do they kind of think something may have happened, or do they know something happened again? You want to require them to investigate it. Telling you, of course, is great. You want to be really clear on what they're going to be telling you and when, but they also need to investigate. They should ideally have a duty to monitor for breaches as well. So the other thing is timing when you're looking at this. Oh, we're going to pause here for data poll question number 2. Do you think data breach is a serious concern? This is sort of like a test on how scary I've been. So I'm anxious to see these results. Right, so it looks like the poll closed, and oh, good. So the result is 100% of you said data breaches are a serious concern. If there was someone had said no, I don't know how I would have been able to continue this presentation. I would have had to just start over again, I think. But I'm glad we are all on the same page with how serious these can be. Let's spend a few moments here on timing. This is a tough one. Quick versus substantive. So sometimes there's a tendency for business to say, if you have a breach, I want to know within 2 hours. Okay, but what are you going to do with that notice? I mean, your vendor is not going to know anything in 2 hours. So then, and now you're on notice and you're just sitting around twiddling your thumbs, waiting for them. And that kind of could create a bad timeline, being like, oh, dear plaintiff's lawyer, yes, we knew about it within 2 hours, but we didn't actually respond to it for 3 weeks because we didn't actually get a substantive notice for 3 weeks of what happened. And that creates a kind of a negative timeline. So you ideally want to balance knowing about something quickly, but also getting a notice that's meaningful and that you can take action in response to. Let's go to the next slide here. And not really going. Okay, here we go. Sample language. These are some things you may have seen in certain contracts, like just tell us about it in 10 days or tell us within 24 hours, but then within 30 days or 5 days, give us all of this detail. These are kind of the two different types of approaches which are going to be balancing. And when you're doing this, couple issues to be going through: the number of days, to 2 days, 10 days, 30 days. If we're going to have to deal with the general timing, was it immediately, promptly, without undue delay, which is a lawyer's favorite? You want to think about the discovery date, like from what point, from what minute does the 2 days start, or does the 72 hours start? Frequency is huge. Initial heads up notice is one thing. A single comprehensive notice often isn't great because that's kind of like the opposite of what we just talked about. Yes, you learn everything, but you may not learn it for 30 days. A bifurcated notice process is probably my favorite, which is like a 2-part with the duty to update. And then you want to make sure you're specifying the content tied to your legal requirements, which your vendor may or may not know, and also tied to your contractual requirements, which they likely will not know. So if a certain customer wants to know how many grapes were affected by the breach, you want to be clear in your agreement. You're going to tell us how many grapes were affected by the breach. You want to be really, really clear on that, so that whatever you're learning is what you need to forward on to your own customer or to the insurance department, for example. You do want to talk about mitigation. Great, you're telling us something, but what are you going to do to fix it? You want to be really clear again and specific about what you expect this vendor to do to mitigate the harms from the breach to both you, your customers, and your members or employees. This is some sample language here, some concepts which we'll get to in the next slide are things like take reasonable steps, kind of vague, but sometimes it's all you can get, to cooperate, to reduce harm, that kind of stuff. Issue spotting checklist for mitigation. Harm to who? It's kind of like mitigate what? Mitigate harm to the vendor, mitigate harm to us, mitigate harm to individuals, mitigate harm to third-party customers. You want to add ideally some extras, like a duty to cooperate, a duty to tell us in writing like what they're doing to mitigate. You often can't mitigate very quickly, which is fine, but give us a plan. Tell us in writing what your goals are and what your steps are. That's really important. And then we want to be kept up to date. Once the breach is done and we're responded to, we still want to know what you're doing to prevent harm, to mitigate the breach, and to make sure it doesn't happen again. some of the mechanics, think about who's directing the mitigation, kind of what's the degree, what's the standard, is it reasonable, best, or just must? Duty to cooperate is really important as well. This is not the time when you need to be in an overly adversarial posture with your vendor, because you need them. Even if they really screwed up, you need them to cooperate. And the best way to ensure that is to get all of this detail out of the way before the breach happens in the agreement, so you have a plan to follow. There's also something regarding delegation I just want to make a quick point on, which is, hey, you had the breach, then you should be the one to fix it. You should be the one to handle it. You're the one who's going to deal with all of our responsibilities. And then moving to the last item, which kind of gets on everyone's radar, is, hey, vendor, you caused the breach. You need to pay us, right? You need to make us whole. Some things like this, if the breaching party shall reimburse the non-breaching party for all direct out-of-pocket costs. If you have a breach, if your vendor has a breach, your business may need to engage counsel. Your business may need to offer credit monitoring, engage a third-party cyber security company. Those aren't all cheap. So you're going to want to have your vendor reimburse you for those costs. This can be caught up in an indemnification clause, but sometimes it's nice to have something more specific to costs rather than claims. Here is the issue spotting checklist. So if you're taking the approach that I'm talking about here with the vendor breach strategy and addendum or a section of your template agreements, think about, what do they owe you? What costs are they going to be covering? Be specific, be very, very specific here. Think about the mechanics. Sometimes a contract only, it's great that they promise you the world, but like, what are the mechanics of actually getting that money? What is the time period for reimbursement? What about a duty to recover from a third-party payer, such as like a cyber insurance company? Duty to offset costs, prior approval of costs, those kind of things. And then certain carve-outs, so maybe you want to say, our insurance is going to cover X, so we're not going to make you pay for X. You have to be really careful to know what your insurance covers, but those are some options to make it more palatable to vendors. And with that, we have like a minute and a half left. So I'm going to pause here and see if there's any last questions. And I apologize in advance again for the gray screen or whatever you're all seeing. All right, well, seeing none, oh, actually a whole bunch just came in, but all thank yous. I appreciate all those kind words. Thank you. But I'm going to turn things back over to Sue now to keep us on schedule.
Hey, Sue, if I could start. Bill, thank
sure.
you so much. This topic is driving everybody crazy, and it has no simple solution, but requires attention. So this was very, very good. And in fact, everybody that was on the session will get a copy of your presentation. We're going to be emailing it directly. So and thank you. Now, Sue, you want to make last minute comments?
I want to blame Bill for jinxing me and talking about how he lost internet connection in his last presentation, because I lost it today, which is why we have a backup. But thank you very much, Bill. We really do appreciate your presentation, and I'm sure we'll have you back to do another one in the future. Hopefully on a week when you're not quite so busy.
Oh, no. Very nice seeing you.
You've given us a lot to think about. Thank you, Bill.
Yeah. We'll now take a short break and come back at 11:15 for our cybersecurity presentation with Steve Shively.